Hi everyone, welcome to week 1 of our course. This is Human Resources Legal Aspects. My name is Alex Wheatley. I'm an attorney at the law firm Fisher Phillips. I'm based out of Portland, Oregon. I'm licensed to practice law in both Oregon and Washington. In just a brief overview, all I do is employment law. I represent on the management side. On the employer side, I represent employers and advise them on how to comply with the myriad employment laws, and then represent employers if and when they do find themselves in litigation or facing demand letters or other sorts of complaints from their employees. My firm, Fisher Phillips, is a nationwide employment law firm. We've got offices in 30 some odd cities and about 300 attorneys, and all the entire firm does is management side labor and employment law. We have particular attorneys who cover traditional labor, which is sort of the union aspects that go along with some workplaces. We also have some immigration attorneys who deal with management side immigration issues. And then a lot of us deal with sort of the bread and butter employment law, including wage and hour law, civil rights and retaliation type claims, whistleblower claims, and broad category of leave and disabilities laws. We'll be focusing in this course on those employment laws, the disability and leave, hiring and firing issues, and wage and hour. This week's module is about hiring and the legal considerations and the practical considerations that go along with hiring employees. It's important because, as this acronym sort of hints at, if you don't make the right decisions when hiring, you end up with bad results. Both bad results as far as performance. You don't end up with the employees who are best suited to performing the job that you need an employee to perform. And also, they can result in really bad outcomes from an employment law litigation perspective. Throughout this course, you will hear me at different times, I'm sure, discuss just how dangerous employment litigation is for employers. And just as a quick overview, I mean, one of the main issues is that the employment laws are written in a very favorable manner towards employees in order to curb some abuses that some employers had been guilty of over the years. And so they're written one way to protect employees, and part of that is that most of the employment laws allow employees to recover whatever attorney's fees they incur in vindicating their rights. As long as they win whatever lawsuit, they usually can collect their attorney's fees. Employers, on the other hand, can almost never collect attorney's fees incurred defending against employee lawsuits, even if the employer wins. So even setting aside the fact that an employee may be able to make out a substantial damages claim, litigation in the employment context is very expensive just because of the attorney fee exposure. If a case is litigated all the way through trial, it's not unsurprising to have attorney's fees in the $100,000 to $150,000 range, if not more, depending on the complexity of the litigation. So it's really important that you understand that garbage in, garbage out, you need to be making good hiring decisions to reduce the risk, both that you have underperforming employees in your company and to reduce the risk of potential litigation. So we're going to talk a bit about how to hire the best candidate you can, both effectively and efficiently, but also lawfully. You can think about the hiring process as sort of an ever finer sifting, an ever finer straining of applicants. At the advertising stage, you're casting a fairly wide net. You're not necessarily trying to trawl the bottom of the ocean and scoop up everything. You only want qualified folks to end up doing your application. So even in your advertising, you want to be targeted. But that's a broad net that you're sending out there to try and get folks interested in applying to your position. And then you start to just sort of narrow down the field, looking for any legitimate and lawful reason to to sort of narrow and exclude certain individuals. And then, again, through the interviews and job offers and resolving contingencies, you're getting down to the 2 or 3 best candidates and trying to make your decision as to who's going to best fit in your company. The place to start, even before you start advertising, is the job description. It's really important that as an employer, you understand exactly what it is that you are trying to hire, right? What position are you trying to fill? I think employers and hiring managers, see a narrow need for a body to fill a particular role and just hire for that purpose without really thinking broadly about, well, exactly what do we want this job to be? What do we want this person to do? And having that front end thought of what are going to be the essential functions, how is this person going to be paid, if it's a new position in particular. If it's a former position that just needs to be filled, you may already generally know what those duties will be, and you just want to articulate them and refine it down to make sure it's accurate and captures everything that you're wanting out of the employee. Job description is really fundamental throughout the employment relationship. It sets the expectations for both the employee and the manager. It lets everyone know what's expected out of that particular job. A good job description is also going to delineate all the essential functions of the job, which can be very important as a piece of evidence down the road if you're trying to establish those essential functions for a disabilities accommodation analysis, or for a wage and hour, exempt versus non-exempt employee analysis. This is a broad general overview of the components of a job description. There are plenty of examples out there online. Certainly your employment attorney, or if you're a member of any of the HR type groups or have access to BNA or any of those databases, you can find plenty of examples of job descriptions and you can work off that template. But it's important, again, not to just have a generic job description and use that. Actually think about what you want that employee doing and be specific in the job description. You want to make sure you're identifying the actual job title, reporting relationships, and then importantly whether the position is going to be exempt or non-exempt. My disclaimer here is that the mere fact that you list something as an essential function or you state that a position is exempt or non-exempt does not particularly make it, or not necessarily make it so. For both those analyses of what are the essential functions and whether the employee's performing exempt duties, they will be determined based on the facts of what the job actually requires. However, again, the job description is a good piece of evidence to show a potential jury or judge what the job did require. So, for example, an essential function may be listed on the job description to lift 100 pounds, but if no one ever has to actually lift 100 pounds, then the employer will be unsuccessful in convincing a judge or jury that that was an essential function of the job. But if the job description states that lifting 25 pounds is required, and in fact lifting 25 pounds is generally required of the job, that job description does help in showing that everyone understood what the essential job functions were at the time of employment. Having a general summary of what the job will be is a good idea. Again, the essential functions, we want to make sure that we are listing the primary things that you are hiring that employee to do. And also, I like to include always that regular attendance is an essential function and necessary. There's Ninth Circuit case law that supports that regular attendance at a job is generally an essential function, but here we can help to bolster that, undesired for but potential future case by including that attendance requirement in the essential functions. If there's going to be any prerequisites, it's good to go ahead and list those as well. There have been examples of times when employees have stated that they fulfill certain prerequisites, and it's ultimately discovered that they do not, and that can be helpful to show that before the employee engaged in some sort of protected activity, that it was clear that having a certain certification or license or something like that was required, and that the termination of that employee, 2 months after they engaged in protected activity, was because the employer discovered that the employee hadn't actually fulfilled that essential function or that prerequisite, and it was not because the employee engaged in protected activity. And at this point on the job description, and we'll see it throughout this course, it's important to sort of reaffirm that at-will employment nature. During the hiring process, one of the fundamental goals is to do nothing that will harm that at-will employment nature. So not make any promises that could possibly be interpreted as promising employment for any particular length, or employment unless and until the employee makes some mistake that would allow for termination for cause or anything along those lines. So here, just having a disclaimer that this position is at will is worthwhile. It doesn't need to be much more involved than that at this point, but just stating that the position is an at-will position is a good idea. Also, at this front end stage, before really even hiring for the position, you want to think about whether or not you're going to require any sort of restrictive covenants. Under Oregon law, a non-compete agreement, so an agreement that actually prohibits the employee from acting in competition with the employer for a certain period of time, is rather difficult to enforce. In a lot of cases, it's impossible. It all depends on we'll talk about it in a minute, but it can be very difficult to enforce. Non-solicitation and non-transaction agreements are not part of that statute that makes enforcement of non-competition agreements difficult. And so non-solicitation and non-transact agreements that say that the employee will not go out and try to solicit the employer's customers for a period of time after employment ends, and non-transact agreements which state that the employee will not do any business with, regardless of whether the employee solicits or the customer of his or her own accord seeks out the employee once they leave. The non-transact prohibits the employee from even doing any business with those customers or former customers. Again, those are carved out. They're governed instead by the common law rule of reasonableness. Generally, this is focused in on there being reasonably limited in time and geographic scope. Rule of thumb is 18 months to 2 years is a reasonable amount of time to impose those restrictions. The geographic scope is more malleable depending on how big the reach was of the employer slash the departing employee. So if you had the nationwide sales agent for Coca-Cola, you might well be able to get a non-solicited, non-transact that is nationwide. But for the most part, if somebody's working in Oregon, doing business in Oregon, you're going to need to restrict it to Oregon or the particular sales area that employee is working on. And then we'll digress a little bit here to talk about contract law real briefly. For contracts to be enforceable, which non-competition, non-solicitation, non-transaction, confidentiality, all these severance agreements, these are all contracts. They're all agreements between two parties. Those require offer, acceptance, and consideration. So there must be an offer of some sort of contract that must be accepted, and there must be consideration exchanged between the parties. And consideration just means something of value or some sort of deprivation that both sides give up. And so an example would be that if I just promise to mow your lawn on Saturday, that's an unenforceable promise. you've exchanged nothing in response to my promise. But if I say, I promise to mow your lawn on Saturday if you'll pay me $20, and you say, I accept, then both of us are giving something up. I'm making a promise to mow your lawn, you're making a promise to pay me. That is consideration, that promise of payment. And where it comes up in employment law in particular is whether or not the employer has given the employee anything to support a particular agreement. I see this most often with severance agreements, where the employee's on their way out and the employer says, will you sign the severance agreement as you're leaving? And the employee does, or the employer even more cynically maybe says, I'll give you your final paycheck if you'll sign this severance agreement, which is a big no-no we'll talk about in a few weeks. That would not be consideration, because the employer is not promising to give the employee anything that the employer is not otherwise obligated to give the employee. There is a split among different states in particular, and even amongst different courts within states, as to whether continued employment is sufficient consideration. So if you have an employee who's already employed and you just come up to them on Tuesday and say, please sign this non-solicitation agreement, there is a risk that that will not be enforceable. Your safest bet is to require execution of these agreements at initial employment, at least of the non-solicitation, non-transaction agreements, upon initial employment or upon some promotion where the employee is getting something extra, and you say, as a condition of my being willing to employ you, or as a condition of my promoting you, I'm asking that you sign this non-transact or non-solicitation or confidentiality agreement. And that would be adequately supported by consideration. There's not really any question there. So that's your safest route. As I said, non-competition agreements themselves are very difficult to enforce in Oregon. For a non-competition agreement to be enforceable, the employer must tell the employee in writing at least 2 weeks before the employment begins that a non-competition will be required. That's why it's really important, if you're going to want a non-competition agreement expressly, then you need to be thinking about this on the front end before you're really even advertising, because you're going to need to build that 2 weeks into your hiring process. Also, the employee must be an exempt employee. We'll talk about that more in the wage and hour section next week, but generally speaking, they must be they must be paid on a salary basis, and they must perform specific job duties such as the executive functions or administrative functions. The employer has to have some protectable interest. That means that the employee needs to be gaining access to some amount of information or some amount of information that's going to make them more competitive with you once they leave than just the average individual. That's usually fairly easy to establish. If you do have an exempt employee in your operation, they're going to know things like customer identities and your processes and things like that. The total amount of the employee's compensation has to meet this particular threshold. The number moves around a bit, and I've actually seen different numbers from different sources, possibly because of the confusion that goes along with the census data there. I have seen that BOLI has pegged it at around $88,000, but I've also heard other folks that have talked about closer to $75,000. So I just suggest that if you're going to think about having a non-competition agreement, you consult an expert to figure out what the specific amount is at that time. And finally, the agreement can't be for longer than 18 months after the end of employment. Switching gears a little bit, once you've decided what job you need to fill, you've got a good job description, you've decided whether or not you're going to require a non-competition agreement or other restrictive covenant, then you want to start advertising and trying to identify potential recruits. It's important to understand that for the most part, the protected classifications, the laws that prohibit discrimination based on particular protected classifications, such as those listed on this slide, apply throughout the entire employment process, not just to employees. they apply to prospective employees as well. And so employers need to be careful that whatever their advertisements are, don't run afoul of these restrictions against discriminating or discouraging individuals that fall into one of these protected classifications from applying. A proper advertisement might include the job qualifications, descriptions of the duties, what schedule you're going to require somebody to work. We do think that you should include the equal opportunity language, that you're an equal opportunity employer. It's also a good idea to go ahead and if you're going to require pre-employment drug screening or background checks, that you go ahead and notify folks in that initial advertising process. That'll just discourage folks that you don't want to really, to put it bluntly, to waste your time having to review applications or potentially interview. Because as we'll see, there are restrictions on the ability to otherwise screen those folks out through the application process. In advertising, you don't want to include anything that's going to run afoul of those EEOC guidances against discrimination in advertising. So anything that's going to suggest a gender preference, with some caveats and exceptions that are too deep for this course. I mean, there are certain positions where it is a bona fide job duty, it's a bona fide requirement of the job that the applicant be of a certain gender or sex. TSA screeners come to mind, that TSA must have employees of both sexes, and so if they don't have an employee of one sex able to conduct pat-down searches for certain people who require, they may have to hire based on gender. And there are other positions where that would be true, but they're unique, and it's important to distinguish between a position that actually where a particular sex is actually a bona fide requirement of the job, and those where there's just a gender stereotype as to which gender is appropriate for that particular job. Also, more subtly, I think statements that suggest an age preference. It's not uncommon to see recent college graduates or retired persons, and an employer may well be coming from a good place, wanting to hire retired persons or something like that, or wanting to hire younger people versus older people. But in Oregon, the projected classification of age goes all the way down to 18 years old, and so you can get in trouble if you're suggesting that preference. Any statements that suggest a refusal to accommodate religious practices, Sunday work required, and you can post what the schedule or the anticipated schedule is, what you think you're wanting somebody to work, but staying away from absolute terms such as required, because there can be a requirement to accommodate, reasonably accommodate religious practices. Words like able-bodied or strong can be problematic due to disability concerns. And again, getting back to not destroying that at-will employment nature, don't have anything in there about long-term employment or stable work or anything like that. So the next step is the employment application. At this point, you're really getting beyond that broad advertising aspect, and you are starting to narrow down the potential candidates based on the applications, based both on the information that is conveyed by the employee on the application, and also, frankly, the way in which the employee completes that application. How neat is it? What does it look like overall? These can be used for both future defensive and offensive purposes, and so that's why it's important not to rely on resumes instead, and to actually tailor your application to your specific area. But you want to be careful to avoid some of those same legal pitfalls that we've been talking about before at this stage as well. As I said, tailor the application to your own needs. Don't just rely on a generic application. One reason is we do have particular restrictions on some aspects of job applications in Oregon, and so you don't want to have a situation where you've just printed a generic job application online that may fly in certain states but doesn't fly in Oregon or Washington for that matter. Don't accept resumes in lieu of applications. The application's serving a purpose for you, and so you want to make sure that you are using that application. I've had a question before about using Indeed or other job hiring type sites, and that those sites will just send candidates. They have their own application processes and their own applications. I think that's fine. I don't think that I think it's also fine though that you as the prospective employer go ahead and have your own application and have whatever candidates Indeed or whoever else sends you fill out your application as well. Have the applicant sign that application and let everybody know what the requirements will be. It is good to have that at-will language disclaimer again at this stage as well. And it's a good idea to go ahead and limit the active period of the application. So the amount of time this application will expire within 60 days or something like that. It's a rare occurrence, but there's a potential that if you've neglected those older applications and you've got somebody sitting out there and eventually they say that the reason that you didn't hire them a year later was because of some protected characteristic, and you can point to the fact that their application had just expired and they had never reapplied as one of the reasons why they weren't hired. It is good to go ahead and have both professional and personal references and have the applicant authorize you to contact those references and seek out information about the employee. That may also reassure whatever past employer you're seeking a reference from. A lot of employers now, for fear of defamation claims, are unwilling to provide anything other than dates of service and rate of pay, a so-called neutral job reference. And if you're able to show that employer that the employee's authorized you to inquire and has authorized that other employer to provide that information, they may be a little bit more forthcoming with the information. It's also a good idea to go ahead and have a statement right above the signature line that requires that all of the information conveyed in the application be truthful. It'll at least give the employee pause if they're exaggerating things or outright lying on the application. It also just provides another example of, as I was saying with the certifications on a job description, if you do discover that there has been a falsification, it can help you in any sort of wrongful discharge claim. It is a legitimate, bona fide, non-discriminatory reason for terminating the employee if they've been untruthful on that. And that can counter any claim by the employee that says, well, sure, I did that, but they also fired me 6 months after I engaged in this protected activity. On the application, we want to stay away from anything that the employee could eventually point to as showing any sort of discrimination on the basis of protected classification. So don't ask about protected classifications on the application itself. Also, just because of privacy concerns, it's a good idea to not have Social Security numbers on applications. That just adds another level of liability to the employer. Applications generally aren't treated as confidentially as, say, medical records, and so having more Social Security numbers floating around is not a good idea. Also, don't include the FCRA authorization, the Fair Credit Reporting Act authorization on the application. If you're going to have a third party do a credit check, then you want to have a standalone FCRA authorization. In Oregon, we have some relatively recent legislative action that has changed some of the hiring processes. So in Oregon, statewide, employers can't inquire about criminal history on an employee's application. This applies to all employers. There's no size limits or particular areas, except for, I will say, the one exception to this is if there is a law or regulation or some other imposition that requires that certain employers consider criminal history. So employees in the banking area, employees at daycares, and a few other types of sensitive positions like that, where there are positive laws that require that employers not employ certain types of criminals. Those employers can ask about that type of criminal history on the job application. Portland went much further. In Portland, employers cannot ask about or even in any way consider criminal history until conditional offer of employment is made if a company has 6 or more employees. So, in Portland, it's much further. It's not just a matter of you can't have the box, so to speak, on the application. In the rest of Oregon, you can't have the box that says, "Are you a felon?" But then as soon as the applicant walks in the door for the interview, you can't ask that question. Portland, that's not the case. You have to go all the way through the interview process and actually give a conditional offer of employment before you're going to ask about that criminal history. And then even then, you can only exclude employees on the basis of criminal history if that criminal history sort of applies to the job, right? So if it's a crime of embezzlement or fraud, clearly that would apply to anybody who touches money in any way, shape, or form. A violent crime would probably be applicable to all positions. A low-level drug crime likely would not be sufficient to exclude an employee from an assembly line type job or anything along those lines. Also, it's important to understand that Oregon employers are also now barred from screening applicants based on pay history or setting compensation on pay history. Oregon's pay equity law is really aimed at trying to level the playing field for women in the workplace and minorities, other minorities in the workplace. And part of that effort is restricting employers from considering past pay in setting pay. The idea being that practice just perpetuates the pay disparity that already exists. So as I was talking about, use that application as a straightener. You're wanting to go through and look and see if there's a good lawful reason to not waste your time interviewing an applicant. So look for incomplete applications. Obviously, if the applicant doesn't meet the basic qualifications of the job, you'll reject them. Potentially overqualification as well. I think that's more case by case, but you don't want to end up having a PhD chemist working as a burger flipper necessarily, because that person may become bored in that job or otherwise not fit well. So look out for people who are overqualified, but I think that's more case by case. Providing only P.O. boxes and 800 numbers as a contact info can be a bit of a red flag in that it can show some level of transience. Same with job hopping. There's a number of things. I would say the failure to sign and date, just if the application's dirty, lots of scratch outs, coffee stains, any of those sorts of things, that's showing a lack of attention to detail and a lack of caring about what that final product looks like. And again, depending on the position you're hiring for, that may be a deal breaker. You don't want to have your even accounts payable, accounts receivable employees or anybody else who's going to be filling out forms and processing paperwork to not have that attention to detail. Gaps in employment history, again, case by case. There can be good reasons and bad reasons you'll want to ask the applicant about. But do look out for those victim license statements. You should be asking for a list of prior employers and the reason the employee left those prior employers. And if there's a number of those that say didn't see eye to eye with the boss, or they didn't appreciate me, or things along those lines, that can be a big red flag. The next stage in the sifting process here is interviewing the applicants. This is once you've really narrowed it down to the prospective employees that are worth you taking the time out of your day to actually interview. Important things to consider are, one, the interviewer is also there representing your company, so you want to think about the company image. If you're trying to hire the best talent, then that individual should be interviewing your company as much as you are interviewing them. And that means that if you're not sending the right person, or if you're not sending the right person to conduct the interview, or that individual is not properly prepared, doesn't understand the process well enough, that can give a bad impression to that prospect, to that recruit, and may hurt your chances. And eventually that recruit may go to one of your competitors. So think about that aspect, and it's not just having a body in the room to ask a bunch of questions. That interview is going both ways. And then we'll look into potential pitfalls, particular types of questions that you're wanting to look at, what documentation you're wanting to get, and then sort of looking at it from a behavior-based standpoint. Overall, at this point, the applicants have made it over that initial threshold, right? That initial obstacle. And that should be, what that should mean is that the people that you're interviewing are all competent and qualified for the position. And now you're trying to pick out the best of them and who you think is going to work best within your organization. Okay, so first looking at pitfalls to avoid, I think the main thing is just thinking about confronting whatever biases one might have, and pretty much everybody does have some implicit biases. If you ask somebody, think of a nurse, more often than not, the person's going to think of a female. If you ask somebody to think of a firefighter, oftentimes people will think of a man first. It's just the way, whether societal or otherwise, our brains have been conditioned, and evolutionarily we've been designed to sort of categorize things that way. So it's important to just take note of that and be willing to take a look inside and see whether you are disqualifying someone for a reason that doesn't relate to how well they're going to be able to do the job. If you had these two individuals applying for your energy lab, one might look more the part, but most would admit that that Mr. Einstein would have been a better addition. Other pitfalls to avoid, you want to get the full story here, so you don't want to be trying to eliminate applicants very quickly. Again, hopefully you've already done that. You've eliminated the applicants who are not qualified, and now the individuals you're meeting with are qualified, at least on paper, and you need to take the time to actually get to know them to figure out whether or not they're going to be the right person for the job. Follow up on things, don't jump to conclusions, and most importantly, don't talk too much. Most job applicants are perfectly happy to let the interviewer do all the talking. That doesn't do the interviewer any good, though, because what you're trying to do is actually get to know that employee. And don't use leading questions. This can be a hard one depending on how individuals are, how comfortable people are with the interviewing process. But you're much more successful in asking open-ended questions than questions that actually suggest the response that you want. You'll enjoy doing this kind of work, right? That's a leading question, right? You don't want to do that. But what kind of work do you enjoy? Where do you see yourself? These are open-ended questions that allow the individual to expand a little bit more and not just say what they think you want to hear. And look for those nonverbal signals. I mean, certainly, depending on the job and the applicant, there may be nerves involved and things like that, which could express some or telegraph some nonverbal signals there just based on nervousness. But if you're looking for things like signs of boredom and not taking the process seriously, you do want to take account of those nonverbal signals. Questions to avoid are much as they are in the other areas that we've talked about. It's anything that could show that you were taking into consideration a protected characteristic. So you don't want to ask about childbearing or child care. That's a very common mistake. Is at some point the interview process can become rather conversational, right? And you are trying to get to know the person, and part of getting to know someone is getting to know what they're like away from the workplace. And so it's not uncommon for topics about families to come up. You should not be asking about them, but it's not uncommon for an employee to say, or a prospective employee to say something about their kids or something along those lines. It's just important not to follow up with, well, okay, so if you have this job, how are you going to be able to take care of those kids? That's not the question. The question is whether or not that employee is going to be able to perform the essential functions of the job you're offering, including regular attendance. And they tell you they can, they tell you they can't, and you need to move on from there. Likewise, some of these other topics may come up in the interview, but you don't want to be asking about them, and you don't want to be dwelling on them in any way, shape, or form. As far as medical questions, before you've made an offer, you really shouldn't be making any sort of medical inquiries other than any sort of medical inquiries. You can ask whether the employee can perform the essential functions of the job with or without a reasonable accommodation. I wouldn't tie this to, does your medical condition allow you to perform the essential functions? It's before an offer is made, don't ask anything about or mention anything about medical issues. Just ask whether they can perform the essential functions of the job. Post-offer pre-hire, employers can generally ask any medical questions as long as they're job-related and consistent with business necessity. So at that point, you can ask, are you going to be able to lift a certain amount or stand for certain periods of time? Is there anything that might prevent you from doing that? Depending on the physical activity required of the job, you may even be able to have physical screenings that go towards whether the person, or even physical tests that go towards whether the person can do the job, such as an agility course for a security guard or something along those lines. Just one more time, sort of beating the dead horse here, do not do anything that's going to jeopardize your at-will employment relationship. Don't make any statements in the interview that suggest that the employee is anything other than an at-will employee who can be fired for any reason and no reason at all, with or without notice. We'll talk more about the at-will issues in the final week when it comes to terminations. So why are we worried about these questions? It's the legal liability. If you've asked about it, if you've written it down anywhere, then everyone's going to assume that was part of your decision-making process. If in the interview somebody says that they have children and you say, how are you going to be able to take care of those kids? And then they don't get the job, there is an inference there that that consideration played a part in your decision not to hire. It is important to document really everything of import in the employment relationship, and the interview is the same. Juries only believe documents, and I say not people. That's not entirely true. They don't believe employers unless there is a document that goes along with it. And so it's important that you do have contemporaneous documentation. We'll talk more about it on the discipline side, but once it comes to documenting some issues, such as tardiness and things like that. It doesn't have to be an involved process. But specifically when it comes to the interviewing process, you do want to have good notes of how the interview went, and make sure that those notes don't suggest any sort of illegal considerations. So if it is important enough to be part of your decision, document it, again, unless it's an illegal type reason. Hopefully no one is taking into consideration any of those protected characteristics when making a hiring decision. If anyone is, that's illegal, it's wrongful, and it's also really stupid if you write it down. But otherwise, make good notes. Make notes about the good points and bad points. What impressed you, didn't impress you about that employee, or prospective employee rather. What did the employee say or didn't say in response to your questions? Once you've got your handwritten notes completed, convert those to a written typed document and get rid of your handwritten notes. Just that allows you a chance to review your notes, make sure there wasn't anything improper, and better craft them for potential future use. Also, don't write your notes on the application, where you may use the application for a different purpose, so you want to keep those separate. Again, as you're documenting things, just make sure you're only documenting legal considerations, and don't try to get cute. Whatever codes you might want to use will be deciphered at some point in time. It's very, very common for applicants or prospective employees to volunteer certain information unsolicitedly. They, whether it's about childcare and status, or it is somebody who's applying for any position and just says, you should know that I suffer from depression and have to miss work occasionally, or any of those sorts of things. So if they offer any of that type of information, just let them know you don't need that information. It won't affect your hiring decision, and don't document the information. At some point in time down the line, you may be able to, especially once a conditional job offer is made, you may be able to require a physical test or some sort of documentation that shows that the employee's going to be able to attend work regularly, which is one of your essential functions on your job description, as we discussed. So electronic screening of applicants, this can be very useful to employers. It can also pose some risks. For the most part, there's nothing necessarily illegal about Googling an applicant before you interview them, or at any point during the hiring process. But at the same time, it can expose you to some information you might not want to know. The one area where I could see this being particularly problematic is with respect to the relatively recent Oregon prohibition on taking criminal history into account at all before a conditional job offer is made. And for that reason alone, I would suggest waiting to dive into the internet until a conditional job offer has been made. Then if you find anything that changes your mind such that you want to actually rescind that conditional job offer, you can do so at that point. But otherwise, you're able to screen these individuals. You may want to, in order to see whether or not the individual is going to work well within your entity, and to see whether you have any information that worries you about that employee. What you know can hurt you. That's why even if you're doing this, you may want to be a little bit more careful about how obvious you're making it that you're doing it. If you get on somebody's public Facebook page and you see posts about their families, and ultimately it becomes clear that you did rely on that to not hire the employee because of childcare issues or something like that, that still can certainly expose to liability. Ignorance can be helpful during this entire process, so you want to weigh the risk versus the benefit and how important the position is. Here I say if you do it after this face-to-face interview, as I just said, because of the newer law, I would wait even until you've given a conditional job offer. And then there are some legal restrictions here beyond even that, which is you can't require that applicants show you private social media accounts, and you can't try to dupe them, or shouldn't try to dupe them into accepting a friend request or otherwise. So that's pretty much the overview of the legal considerations that you want to be taking into account when you're trying to hire. Also practically, you are trying to find the best person for the job, and that goes beyond the bare bones legal restrictions on what you can and can't ask and do and so on and so forth, or what you can and can't consider when evaluating whether to hire someone. And those are important things, but beyond that, you want to make sure that practically you're doing what you can to really get to know the applicant and make sure that they're going to work for what you want them to do. Obviously, if you're hiring a low-level line employee who's more replaceable, that might mean not spending as much time necessarily. But if you're hiring the general manager of your business, you want to make sure that you're doing what you can to make sure that's the right person for the job, not just relying on a 20-minute cup of coffee with somebody for the interview and their resume and saying you're hired. I really like this article, How to Hire the Right Person. Is in the New York Times, or was in the New York Times business section a while back. And I just thought it did a good job of sort of highlighting some of the best practices out there that one can consider. So you can find it, read it on how to hire the best talent. Avoid that standard job interview. Try to get the employee or the prospective employee into different settings, maybe a meal type setting, get them into your actual facility, have them move around within the facility, see how they interact with other employees, and evaluate them on that. I mean, their poise, their courteousness, so on and so forth. Again, the best applicants usually are going to be interviewing the company as much as the company's interviewing them. So make sure you're giving them opportunities to ask questions. Make sure that you're evaluating whether or not it seems like that candidate is trying to make sure that this is a good fit for them. The more they buy in that this is the right spot and less just a job, the better off they're going to do and the better off your business is going to be. Do check references to the extent you can get them. Also, it's not a bad idea, especially depending on the position, to get other employees, not just the hiring manager, to meet with the individual and try to get a sense of what they think about that individual or that prospective employee. Push for diversity, and diversity of all sorts, right? Diversity of backgrounds, diversity of education, diversity of work experience. Those are valuable things in business because they allow for a diversity of ideas, and the more ideas you have in more or less your little marketplace of ideas within your company, the more you're able to sift through those and pick the best idea and end up with the best result. This doesn't mean affirmative action necessarily, or hiring based solely on, we need to have a person of X type hired so that we're diverse. You should not make it the be all end all, particularly now. I mean, there's ways to design legal affirmative action programs, but they're difficult, and I think they're particularly difficult in private industry. So it's more a matter of, I'm not going to go out and just hire somebody because they are this type of person, but it certainly will be a consideration that I take into account if I have two, or more relatively equal candidates. It's maybe a consideration I take into account. And finally, you can assign homework. I'd be aware that working interviews can be problematic. If you're having the person do productive work that is actually work of the company for which it makes money, or for which it would otherwise have to pay someone to do, that you can be in hot water, because that can be considered a compensable activity for which that prospective employee needs to be paid. More, I would give a hypothetical and see how the person would respond to that real world problem that they might see. And that concludes our first week. I look forward to this course. As always, if you have any questions or concerns, please do feel free to reach out to me, either at the email address or phone number you see here, or through the online course system. I want this to be valuable to you, and any feedback you can give me to make sure that it is very much appreciated. And with that, until next week, have a good one. Thank you. Bye.